Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, had to go to court this morning in Seattle Municipal Court, like the worst place in the world, and spend all morning sitting around waiting to do about a 10-minute hearing. So I got some time on the phone, was going through X, found a long thread from Miss Hannah Hill over at the National Association for Gun Rights, who, if you happen to not know personally, is actually an incredibly pleasant person to be around. However, it was obvious that she was incredibly salty on a Monday morning, pretty upset about something, and I got to thinking like, wow, what got Hannah all worked up in a storm? Well, then I went and took a look at the motion she was talking about. We're going to talk about it today because I want you to understand how if we allow the rule of law to literally be reframed like a news story, we're going to lose every single argument moving forward. So today, let's spend a few minutes and let's talk about an infuriating argument in favor of gun bans. Okay, America, we're going to take a case that right now is kicking around in Colorado and use it to illustrate a point that you all need to be aware of, which is that if we continue to allow the civilian disarmament crowd to reframe not just the issues, but reframe the rule of law, there is literally no gun argument that we could ever win moving forward. The case we're talking about today is Rocky Mountain gun owners versus the town of Superior. This is a challenge to the town of Superior as well as a handful of other Colorado municipalities who have passed their own assault weapon ban and magazine ban. It's a case that's obviously brought to us by our good friends at RMGO as well as the National Association for Gun Rights, which means we're going to have links for both of them down in the description box below. Okay, so I said that this was very infuriating. It starts from an infuriating procedural posture, which is this is a renewed motion for summary judgment by the defendants just for the court to throw these lawsuits out. And what they're basically saying here is that, listen, on the pleadings alone, we prevail. There's no reason to have discovery. There's no reason to have a trial. There's no reason to make a record. Judge, you just need to throw this out. And I should point out, since it's a renewed motion for summary judgment, this is the second time they have filed that motion. Now, the other thing that is amazingly infuriating, and we've seen this recently with this horrific knife attack and the murder which took place in North Carolina of Irina Zarutska, the Ukrainian immigrant, where literally mainstream media has completely reframed the issue as the problem being that there were cameras that captured this issue. We are allowing those on the political left to routinely reframe issues so that they're not even connected with reality. And it's actually gotten to the point now where those that are promoting civilian disarmament are actually reframing and getting away with it the actual rules of law. Let me show you how the defendants here are reframing this issue. As relevant here, the burden at step one includes demonstrating that the item at issue is an arm that is in common use for self-defense. No, it's not. It's in common use for any lawful purpose. Self-defense just happens to be one of them, okay? And then, of course, when it comes to the historical precedent necessary to actually justify these laws, they reframe it this way. Importantly, the government need not identify a historical twin or precise historical analog, but may instead rely on broader historical principles. Or put other ways,
you got Raheem-Mead.
So let me explain to you this very dangerous equation that, if accepted, would literally preclude us from ever winning any Second Amendment argument moving forward. Okay, it is a dangerous combination of in common use for self-defense plus a heavy dose of Raheem-Mead. Now, framing the issue as in common use for self-defense allows a court to find that the Second Amendment does not even apply at all. Raheem-Mead means that even if they do find the Second Amendment applies and we get into the history, close or sort of close or kind of close is going to be good enough. Don't believe me? Well, here's what the defendants argue in this case. Plaintiff's challenge fails at step one of the Bruin-Raheem-Mead framework because they have not met their burden of demonstrating that assault weapons and LCMs are in common use today for self-defense. Okay, so understand that when the courts know there's absolutely no historical precedent that's going to back this law up, they've got to find the escape hatch in step one, which is, hey, we got to make sure the Second Amendment does not even apply here. When we frame the issue as in common use for self-defense, It allows a court then to create what is called an evidentiary impossibility. That means the plaintiffs will never meet an evidentiary standard to move forward in their lawsuit. It looks like this. Plaintiffs have failed to adduce any evidence that assault weapons and LCMs are in common use today for self-defense. And listen, this tolerance for the judicial reframing of the rules of law has emboldened people like those defending the civilian disarmament moves here into Colorado to the point where they are literally just misstating every rule of law. Consider this. Assault weapons and large capacity magazines are dangerous and unusual. Now, we have always stated that, listen, if we're going to talk about what's in common use for self-defense or what's appropriate for self-defense, we clearly are injecting back into it a balancing test. But if we don't have a balancing test there, we've still placed a balancing test over here into the historical analysis portion, because now with the overbroad reading of Rahimi, or as we like to call it,
you got Rahimi'd.
It allows a court to balance just how close to the ballpark they need to be, and sometimes it's not even in the same city. And where most of those who are defending these bans are at least trying to claim that they're not asking to re-inject balancing tests back into the equation. I will give credit to the defendants here because they flat out just come out and ask for it. This is how they frame it. The ordinance impose at most a minimal burden on self-defense that is comparable to the burden imposed by historical analogs. Any burden imposed by the ordinance is further justified by the same concerns that motivated regulations of especially dangerous weaponry throughout our nation's history. Defendants have thus carried their burden at step 2 of the Bruin-Rahimi analysis. And that, my friends, is why I'm guessing, and I'm only guessing, that Miss Hannah Hill was pretty worked up this morning. Now listen, the case once again is RMGO v. Superior. You guys need to pay attention to what the defendants are arguing here. If these rules of law were ever adopted, I'm serious, there is not a single Second Amendment case we could ever win if that was the standard. We're going to go ahead and link up their motion for summary judgment down below so that you guys can geek out on it for yourself. You don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.